Good morning. I caught bits and pieces of this debate between Rocker T, a commenter, and Blue Bacon. And I want to give Rocker T a helpful hint on how to debate Blue Bacon. The way to debate Blue Bacon is to stick to one point, which has two subparts. Just stick to it, be relentless on it, don't walk away from it, don't let Bacon walk away from it. Stick on 2 points. And the 2 points are reflected in what Blue Bacon chose to title this: Is it illegal to film a restricted military installation? Obviously, we're dealing with 18 U.S.C. 795, and it is photographing and sketching defense installations, and it allows the president to define what those military and naval installations are. So anything that Blue Bacon wants to define it has to be from the president's definition. Blue Bacon will try to bring in the Army calls it this, the Navy calls it that, a dictionary definition says this other statute says this. But the problem is that in order for 18 U.S.C. 795 to work, the president has to define those certain things. So we are forced by the statute to use the president's definition. And this is the president's definition. We've seen this before. It's Executive Order 10104. Now, 10104, he hereby defines the following as vital military and naval installations requiring protection against the general dissemination of information relative thereto. And Blue Bacon will happily read this part right here. And this is where he ends it. The Secretary of the Army has designated this base as restricted, and a base is an installation. And so it's an installation that's been designated as restricted, and therefore, case over, quaderat demonstratum, I win, and I'm going home. And he completely ignores the and it has to be located within a base. It has to be located within a base. Located within a base. Or one of the other things, but it has to be located within something. And those some things are what we typically call bases. We call it an Air Force reservation. We call it a proving ground. We call it a range. We call it a camp. We call it a fort. I mean, these are what we call those things. And it has to be these vital military and naval installations have to be located within those. If it's not located within it, it's not meeting with the definition. So that's problem number one for Blue Bacon. Don't let him off that. It has to be located within. It has to. That is the definition. The statute requires the definition. The president has provided the definition. It has to be located within. Issue number two that he falls short on is the restricted. Now, restricted, as we all know from Executive Order 13526, is no longer a classification. Classification levels now are only top secret, secret, and confidential. And except as otherwise provided by statute, no other terms shall be used to identify United States classified information. Well, what Blue Bacon is going to argue, and what he always tries to argue, is that this allows the Army, Navy, or Air Force, or Secretary of Defense to designate something as restricted. And he thinks that's still valid. Well, it's not, for a variety of reasons. This statute deals with information. Photographs, sketches, pictures, drawings, maps, and graphical representations all contain information, the dissemination of information. They don't want photographs of these vital military installations getting out to the public. That is what this is designed to prevent, making the photograph so that it can't be disseminated. It's in Chapter 37, Espionage and Censorship. Censorship is, of course, about the dissemination of information. What is espionage? Well, for those of you who don't know, it's the practice of spying or of using spies, typically by governments, to obtain political and military information. This is about information. And you may notice that this is called classified national security information, and this deals with national defense information. If that's not enough for you, I'm going to throw one other little thing into the pie here. This is Congressional Research Service. This is actually from the portion of the government that does the research for Congress. It is part of Congress's little research service. And they prepare these for the members and committees of Congress. And you may notice that on page 6, or is this page? Oh, I guess it's page 3, but it's on page 6 of the PDF. February 1st, 1950, Harry S. Truman issued Executive Order 10104. That's what we're dealing with. And it is an executive order on classified information. So this is an executive order on classified information. And that's why they use classified, designated, or marked, because that's how they used to refer to classified information. Things are classified, designated, or marked as classified, or confidential, top secret, whatever. You get what I'm saying. So when the military to this day marks a base as restricted, when they put a sign up that says restricted, what they're actually referring to is access being restricted, not the information of that being restricted, but the access to it being restricted, and perhaps your rights while on the base being restricted. It has to do with what goes on inside the base. This statute right here doesn't deal with necessarily what goes on in the base. You can't draw a picture of a top secret, secret, or confidential vital military installation at your kitchen table. You can't do it. You're not allowed to do it by the statute. So I want to make it very clear that it is classified information. That is what this is dealing with. 18 U.S.C. 795 is dealing with classified information. Executive Order 10104 is dealing with classified information. And the President's Executive Order 13526 makes it so that you can no longer have information classified as restricted. So his restricted is gone as far as being applicable to 10104, because this is a subsequent executive order, so it does redefine what's going on in a previous executive order, and therefore his argument is going to fail. So his argument fails on 2 levels. There are other levels his argument fails on, but as far as winning in a debate, you want to stick to your big guns and don't let them off. Your big guns are, number 1, a military base is not an installation according to Executive Order 10104 and 18 U.S.C. 795. So his premise fails there, and restricted is no longer useful for identifying a vital military installation under 10104 due to 13526 eliminating that as a classification. So it fails on 2 big ways. Stick to those strong points. Don't let them off. Don't just, whenever he tries to bring up, this dictionary definition says this statute says this, in the military, we constantly refer to it as this, the DOD refers to this base as an installation, etc. It doesn't fucking matter. The Executive Order 10104 does not give the Secretary of Defense or any of the other secretaries the right to do anything other than designate, mark, or classify things as top secret, secret, confidential, or restricted. It does not give them the ability to change anything subsequent to this and. So they can't ignore it. Anyway, I hope that makes sense to you. I hope that helps you out in subsequent debates. Thanks for watching. Have a great morning.